Rule 39. Execution, satisfaction, and effect of judgments. Section 36. Examination of judgment obligor when judgment unsatisfied. When the return of a writ of execution issued against property of a judgment obligor or any one of several obligors in the same judgment shows that the judgment remains unsatisfied in whole or in part, the judgment obligee, at any time after such return is made, shall be entitled to an order from the court which rendered the said judgment, requiring such judgment obligor to appear and be examined concerning his property and income before such court or before a commissioner appointed by it, at a specified time and place, and proceedings may thereupon be had for the application of the property and income of the judgment obligor towards the satisfaction of the judgment. But no judgment obligor shall be so required to appear before a court or commissioner outside the province or city in which such obligor resides or is found. Section 37. Examination of obligor of judgment obligor. When the return of a writ of execution against the property of a judgment obligor shows that the judgment remains unsatisfied, in whole or in part, and upon proof to the satisfaction of the court which issued the writ, that a person, corporation, or other juridical entity has property of such judgment obligor or is indebted to him, the court may, by an order, require such person, corporation, or other juridical entity, or any officer or member thereof, to appear before the court or a commissioner appointed by it, at a time and place within the province or city where such debtor resides or is found, and be examined concerning the same. The service of the order shall bind all credits due the judgment obligor, and all money and property of the judgment obligor in the possession or in the control of such person, corporation, or juridical entity from the time of service, and the court may also require notice of such proceedings to be given to any party to the action in such manner as it may deem proper. Section 38. Enforcement of attendance and conduct of examination. A party or other person may be compelled, by an order or subpoena, to attend before the court or commissioner to testify, as provided in the two preceding sections, and upon failure to obey such order or subpoena, or to be sworn, or to answer as a witness, or to subscribe his deposition, may be punished for contempt as in other cases. Examinations shall not be unduly prolonged, but the proceedings may be adjourned from time to time until they are completed. If the examination is before a commissioner, he must take it in writing and certify it to the court. All examinations and answers before a court or commissioner must be under oath, and when a corporation or other juridical entity answers, it must be on the oath of an authorized officer or agent thereof. Section 39. Obligor may pay execution against obligee. After a writ of execution against property has been issued, a person indebted to the judgment obligor may pay to the sheriff holding the writ of execution the amount of his debt or so much thereof as may be necessary to satisfy the judgment in the manner prescribed in Section 9 of this rule, and the sheriff's receipt shall be a sufficient discharge for the amount so paid or directed to be credited by the judgment obligee on the execution. Section 40. Order for application of property and income to satisfaction of judgment. The court may order any property of the judgment obligor or money due him not exempt from execution in the hands of either himself or another person, or of a corporation or other juridical entity, to be applied to the satisfaction of the judgment, subject to any prior rights over such property. If, upon investigation of his current income and expenses, it appears that the earnings of the judgment obligor for his personal services are more than necessary for the support of his family, the court may order that he pay the judgment in fixed monthly installments, and upon his failure to pay any such installment when due, without good cause, may punish him for indirect contempt. Section 41. Appointment of receiver. The court may appoint a receiver of the property of the judgment obligor, and it may also forbid a transfer or other disposition of or any interference with the property of the judgment obligor not exempt from execution. Section 42. Sale of ascertainable interest of judgment obligor in real estate. If it appears that the judgment obligor has an interest in real estate in the place in which proceedings are had, as mortgagor or mortgagee or otherwise, and his interest therein can be ascertained without controversy, the receiver may be ordered to sell and convey such real estate or the interest of the obligor therein, and such sale shall be conducted in all respects in the same manner as is provided for the sale of real estate upon execution, and the proceedings thereon shall be approved by the court before the execution of the deed. Section 43. Proceedings when indebtedness denied or another person claims the property. If it appears that a person or corporation alleged to have property of the judgment obligor or to be indebted to him claims an interest in the property adverse to him or denies the debt, the court may authorize, by an order made to that effect, the judgment obligee to institute an action against such person or corporation for the recovery of such interest or debt, forbid a transfer or other disposition of such interest or debt within 120 days from notice of the order, and may punish disobedience of such order as for contempt. Such order may be modified or vacated at any time by the court which issued it, or by the court in which the action is brought, upon such terms as may be just. Section 44. Entry of satisfaction of judgment by clerk of court. Satisfaction of a judgment shall be entered by the clerk of court in the court docket, and in the execution book, upon the return of a writ of execution showing the full satisfaction of the judgment, or upon the filing of an admission to the satisfaction of the judgment, executed and acknowledged in the same manner as a conveyance of real property, by the judgment obligee or by his counsel, unless a revocation of his authority is filed, or upon the endorsement of such admission by the judgment obligee or his counsel on the face of the record of the judgment. Section 45. Entry of satisfaction with or without admission. When a judgment is satisfied in fact or otherwise than upon an execution, on demand of the judgment obligor, the judgment obligee or his counsel must execute and acknowledge or endorse an admission of the satisfaction as provided in the last preceding section, and after notice and upon motion, the court may order either the judgment obligee or his counsel to do so, or may order the entry of satisfaction to be made without such admission. Section 46. When principal bound by judgment against surety. When a judgment is rendered against a party who stands as surety for another, the latter is also bound from the time that he has notice of the action or proceeding, and an opportunity at the surety's request to join in the defense. Section 47. Effect of judgments or final orders. The effect of a judgment or final order rendered by a court of the Philippines having jurisdiction to pronounce the judgment or final order may be as follows. In case of a judgment or final order against a specific thing, or in respect to the probate of a will, or the administration of the estate of a deceased person, or in respect to the personal, political, or legal condition or status of a particular person, or his relationship to another, the judgment or final order is conclusive upon the title to the thing, the will or administration, or the condition, status, or relationship of the person. However, the probate of a will or granting of letters of administration shall only be prima facie evidence of the death of the testator or intestate. In other cases, the judgment or final order is, with respect to the matter directly adjudged, or as to any other matter that could have been raised in relation thereto, conclusive between the parties and their successors in interest by title subsequent to the commencement of the action or special proceeding, litigating for the same thing and under the same title and in the same capacity. And in any other litigation between the same parties or their successors in interest, that only is deemed to have been adjudged in a former judgment or final order, which appears upon its face to have been so adjudged, or which was actually and necessarily included therein or necessary thereto. Section 48. Effect of foreign judgments or final orders. The effect of a judgment or final order of a tribunal of a foreign country having jurisdiction to render the judgment or final order is as follows. In case of a judgment or final order upon a specific thing, the judgment or final order is conclusive upon the title to the thing. And in case of a judgment or final order against a person, the judgment or final order is presumptive evidence of a right as between the parties and their successors in interest by a subsequent title. In either case, the judgment or final order may be repelled by evidence of a want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact.